Trying
Why
to.
didn't you pull over?
She refused to get out of the vehicle and had to be assisted out by officers. She was afforded that explanation that it was because of expired registration. It was only because of her action of not cooperating with past turning over her ID and identifying herself that the
CR
officer
008-561, State versus Veronica Callahan. Can I have parties announced?
Sworn Espinoza for the state.
Matthew Allen for Miss Callahan.
And are you Miss Callahan?
Yes, ma'am.
All right. You entered a plea on January 27th. According to your plea, the state was proceeding on count one, waiving the enhancements. Punishment is to be assessed at a cap of 6 years in the prison. There's a $1,200 fine. The state is opposed to your application. They're taking in consideration 2025 CR 014278. Have both parties had a chance to review the PSI and TAP evaluation?
Yes, Judge.
Yes, Your Honor.
Are there any objections?
None from the state, Your Honor.
No, Your Honor.
Any objections to the court reviewing the PSI and TAP evaluation?
No, Your Honor.
No, Judge, sorry.
All right, and state you're opposed. Do you have any witnesses?
No, Your Honor, just briefly.
Defense, do you have any witnesses?
No, Your Honor. Just argument as well.
Right, just give me a moment. All right. State, you may proceed.
Your Honor, we ask that you deny Ms. Callahan's applications and sentence to a cap of 6 years in the prison. Ms. Callahan has criminal history. She's been convicted of 2 DWIs, a manufacture and delivery of a controlled substance, PG1, as well as the possession of a controlled substance, PG1, 4 to 200 grams, as well as another possession in 2016. Of these cases, she's been granted probation in 4 of these, 3 of which she was granted probation resulted in motions to revoke and sentencing either into the respective Bexar County Jail or TDC. Ms. Callahan has been given chances on these probations and ultimately cannot comport her behavior to comply with the rules and conditions laid out before her. Based on the PSI and TAP, Ms. Callahan's in the pre-contemplation stage. We can see here when she recounts the facts of this underlying case. She essentially blames the officer. She said that she drove away because he reached his hand inside of her vehicle without providing a reason for the stop. However, she was afforded that explanation that it was because of expired registration. It was only because of her action of not cooperating with past turning over her ID and identifying herself that the officer attempted to open the door to assist her out of the vehicle for non-compliance. She then drove off, and it was only after her vehicle was spiked, the rear tires had blown out, and there were multiple patrol units following, both marked and unmarked, that Miss Callahan stopped. Once she stopped, she still did not comply. She refused to get out of the vehicle and had to be assisted out by officers. Your Honor, Miss Callahan alleges that she has ceased majority of her drug usage throughout her life. However, I think it's perplexing that she expects the court or asks the court to believe that she has no usage. She merely just possesses narcotics. So because of these reasons, Judge, we'd ask that you deny her applications and sentence to a cap of 6 years.
Yes, Your Honor. The criminal history is what it is. So she was on parole. She completed that. As far as the instant offense, it's not a drug case. It's an evading arrest case. Her recitation of the facts are just that. It's a recitation. It doesn't say, I'm not guilty of evading arrest because the officer reached into the vehicle. It's just her recounting what happened. Obviously, she's here because she's taking responsibility. She called the police even when she was driving, and we've had multiple conversations. 1, you can't take off when a police officer is there. 2, if you did, when you call the police and there's multiple other officers there, you pull off to the side of the road. You don't get to choose where you stop. And she understands that. She understands that, takes responsibility. That's why she's here today. She's not saying I didn't evade arrest or that there was some legal reason why I was able to not comply with the officer's commands. And that's why she's here, because she took a plea to accept responsibility. Since she's been out now, as far as the PSI goes, it says here current address. She actually does now have a stable address here in San Antonio, Texas. So she's not homeless, which helps with obviously trying to.
Why didn't you pull over?
The reason she didn't pull over is because she didn't feel that the officer explained anything. She thought she just got pulled over, and then he was reaching his hands into the vehicle. She felt unsafe. That's why she left and called the police herself.
So why did they have to put spikes down?
Again, that's because she was then trying to say, well, she was going to feel safe if she went to her house. So she's not driving at a high rate of speed, but we've had that conversation before. And so something from probation would be like a cognitive course, and thinking and critical decision making, because obviously that's an error in judgment. And that's a mistake. That's why she's here. As far as she does have a stable home, she actually has two jobs. One is a home health care worker, and I know the court sometimes does not allow people, but she has another job where she helps remodel a business for a man named James. She provided a letter from him to probation as well. So we have talked about this court and home health care working, and that's why she has another job set up and is already working that. Like I said, her housing, she actually had a trailer where she paid an individual $4,000 to live there. Well, that individual is not there any longer, and his wife is not agreeing with that. So she lost out on that money, but again, she's found other places. Mental health, she had been diagnosed a long time ago with manic depressant and bipolar. Again, she is working. She has support here. Paul Dickens is here in the courtroom, and he shows up. She showed up to court yesterday because she's heard this court say, "Do not show up late." She showed up a day early. She takes this case seriously. I don't see how sending her to prison sends any message or helps anybody. Again, she can take drug tests. She can work. She has housing. She can take a cognitive course. She can do a mental health evaluation. She even explained about that some of these things during the interview, she was crying because it was bringing up past things. And so she tried to be open and honest about it, about her past. And so again, they cognitive behavioral therapy, again, there's some adverse childhood experiences. She has had a pretty good childhood. I just think that the court can put conditions in place that allows Miss Callahan to continue to support herself, get better, and protect the community all at once. And so we're asking this court to give Miss Callahan just an opportunity to go on probation. I understand she had been on probation a while back and didn't take advantage of that. But she is a different individual here today. She wants to take responsibility. She does want to show the court and herself and her support system that she can follow this court's orders.
May I return the question
About
the reason of
Do y'all need to step back?
well, when that's the child is supervisor. The reason being was that he was
Yeah. So she had conversations with the supervisor of SAPD about the interaction and some of the ways that were done. And so, but again, that's after the fact. That doesn't absolve her from it. But she has tried to take responsibility, examine herself and her responsibility in that situation. And obviously, she was wrong, and that's why she's here today.
State.
Your Honor, I would just ask the court to deny applications. Ms. Callahan when asked how supervision would help her first statement was, it would definitely help me so I don't lose my freedom. I think that's what is exhibited here. Ms. Callahan thinks her freedom is more important than the law. She thinks that she can flee because she feels unsafe. And at what point are we to show Ms. Callahan that you must comport and comply, and you can't keep running from things because you think you're right? So I don't believe she would be a good applicant or candidate for any sort of probation judge. And while this court may and will probably be able to accommodate and target some of the issues Ms. Callahan experiences, I don't think she is deserving of that chance because she's shown she cannot comply.
All right. Anything you wish to say? I mean, if you want to say something, then I'll have to put you under oath. State will have a chance to ask questions.
I just know that.
All right, no.
No,
Do you want,
I don't want to.
Okay. No, Your Honor.
you're sure? Ms. Callahan, what I'm telling you, if there's something you want to say to me, then what I have to do is I have to swear you in. And then I will listen to whatever you want to say to me, but the state will have an opportunity to ask you questions as well.
Mhm.
So do you need to speak with her concerning that, counsel?
No, Your Honor. We've spoken about it. And no, she doesn't wish to talk other than what I've explained, and what she said.
All right, Ms. Callahan, I reviewed the PSI, the TAP evaluation. I've listened to your attorney and listened to the state. I just don't think you're a good candidate for probation. Okay. I'm going to find you guilty, taking consideration 2025 CR 014278. There's a $1,200 fine, time and money run concurrent. I request the therapeutic community, and I'll sentence you to 3 years in the prison and give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Right to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney.
And each
I
count
think
is
the $1,000
aggravated robbery?
It's an aggravated robbery. Count 2 is a felon possession.
All right, so, the paperwork,
We're gonna proceed on count 1 only.
There we, I was just gonna say, yeah,
okay.
we're good.
All right, because I was like, the paperwork is off then. All right, so any objection to the waiver of count 2?
No objections, Your Honor.
All right, did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with aggravated robbery? That's a first-degree felony. Range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes to both, Judge.
Mr. Villarreal, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No,
Are you satisfied with the way you've been represented?
very much.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, I did.
According to the plea, punishment is to be assessed at 18 years in the prison. There's a $2,000 fine, affirmative finding of deadly weapon, no applications. The state will take in consideration 2022 CR 8530. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Judge.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Judge.
Then to the offense as charged in count 1, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
State offers states exhibit number 1 in attachments.
No objections, Judge.
Did you review the waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes.
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor, just that he's taking responsibility. We hope the court will follow the plea bargain, Judge.
All right, the court will find you guilty. The court will sentence you to 18 years in the prison, give you credit for any time served. There's an affirmative finding of deadly weapon, a $2,000 fine, time and money to rank concurrence. Take into consideration 2022 CR 8530. There's to be no contact with Rosa Hernandez de Leon, Wells Fargo, or Walmart. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am, I did.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. You're gonna have to change your ways.
Yes, ma'am.
Otherwise, you're gonna spend the rest of your life in prison, all behind things. If you
Yes.
want things, you need to get a job to earn things. You understand?
It's my last run right here.
All right, well, I mean, how old are you?
53.
Yeah, this had better be your last run. All right, good luck to you.
Thank you. God bless you.
Oh, thank you. God bless you too.